Thanks for joining us. This is a great webinar. Looking forward to this. My name is Paul Hitchcock, and I am with Barth Calderon, headquartered there in Orange County, California. We are an asset protection, estate planning, and business planning firm with about 12,000 clients across the country. And this is a great webinar with two experts. Phil Shekerlian is an attorney at the firm, handles estate planning, asset protection, probate, and trust, many real estate issues for landlords. And Sakeenah Redmond is the founder of the SNR Law Group. Sakeenah, we've gotten to know each other a bit here recently. Welcome, both of you.
Thank you.
Yeah. And I want to say a couple things as we get into this is we are recording this, so the replay will go out afterwards. So check your emails for that. And I'm going to, as we start here with Sakeenah, I'm going to put a link into the chat to get a complimentary one-on-one with Sakeenah and or Phil. If questions come up and you want to get one-on-one, they have some issues going on, feel free to use that link and you can book that free call. That can be a call or a Zoom call. And we're going to get into it. All right. So Sakeenah, let's start with you. And what I want to start off with is going to follow the agenda here that we laid out for everybody is the most common reasons landlords get sued. And we've got a list here. I want to comment habitability claims. What do we need to know about that?
So for habitability claims, I think I want to start before I even go into habitability. One of the biggest misconceptions I get from property owners or landlords is that I've owned rental property and for years, and I've never, ever had a problem. And, the reality is the lawsuits usually don't happen because someone intentionally broke the law. It's because there's small operational mishaps that compound over a period of time. And habitability is one of those things. One of the fastest way a landlord ends up in court is because of habitability issue. And that consists of like water leaks, mold, infestations, plumbing, sewage issues, electrical hazards. Those are things that are considered habitable, like uninhabitable, I should say. And so a landlord has to be very careful in leaving it to the tenant to inform them of issues. And I say that to say, I think what landlords forget is that you also have a duty to inspect, right? You can't just leave it to the tenant per se, although the tenant does have a contractual duty to let the landlord know of any issues that may arise. And some of the issues that I find in the habitability cases are landlords failing to act within a reasonable time. They wait too long, or sometimes they're waiting for their insurance company. Let's say there's a big leak that occurs, and this leak is moisture, which can cause mold and other issues related to the property. And the landlord wants to run it through their insurance company. And so insurance is slow, and that can cause a huge delay in being able to respond to this issue within what the legal world would call a reasonable time frame. And so you have to be careful of that. You can't just tell your tenant, oh, well, it's a month later and I'm waiting on the insurance company. I see 2 months later, I'm still waiting on my insurance company. And the issue in the property hasn't been resolved yet. And so I see that happen, which can get the landlord in trouble when it comes to habitability issues. I see a mold obviously being a big factor, not taking care of that, not doing the proper testing. Sometimes what I see, it'll be mold in the property or something that appears to be mold, because you can't just look at it and say, oh, this is mold, right? You have to get it tested.
Because not all mold is horrible mold, right? You can clean it up. It's got to be a certain type of mold. So what do you do when there's mold? Because we see that at our firm, a lot of these, landlords come in, their liability, they're getting sued for black mold or whatever, respiratory issues. What do you advise landlords to do if there is mold? How do you jump on it?
The first thing is they want to get it tested. They want to know what type of mold is in the property. And when they get it tested, then they have to get it remediated with a professional company. It's going to be important because they'll give them the documentation needed to, once the remediation is done, for them to test that area again to make sure there's no more moisture and there's no more mold in either on the surface or in the air, because it can be in two places. And once it's disturbed, it really goes into the air. So you have to be careful before you want to disturb the mold. You want to get it tested.
And
Sakina, yeah, go.
one
Yeah,
thing
Phil.
is that, you don't want to rely on the tenants because for whatever reason, mold is a trigger word. We get clients that are actually tenants and they will call me because, I'm the only attorney that they know. They don't typically deal with attorneys or simple people that don't have that. And they call me and they say, "Hey, there's mold in my house. Can I sue my landlord? Can I get a lot of money for this?" Mold makes money signs
Yeah,
go off in their head. So it's not something you want to rely on the tenant to help you with. They're looking for a payday.
yeah, no, well said. Sakina, as we blaze through these, what about issues such as security deposit disputes and fair housing allegations? What do you see there?
With security deposits, the common thing I see with security deposits is the landlord deducting too much money from the security deposit. So let me give you an example. One would be, let's say the property needs to be repainted. The landlord forgets that painting has a lifespan. And so if the house wasn't painted prior to the tenant moving in and the tenants lived there for several years, then you can't just charge the tenant for the full paint that is needed once the tenant moves out. Why, you have to prorate. If it's beyond the lifespan, then you can't charge the tenant at all, at least not for the painting. Now, you might be able to charge the tenant for damage to the wall, right? That is outside of the normal wear and tear. But you have to be very careful of the deductions that you make. And what's really important is to take pictures prior to the tenant moving in. You take pictures of the property when the tenants move out. And then whatever repairs that you're making, you take pictures to show that the property was repaired. That's the proper way to do it. So what I see commonly is landlords deducting too much money for cleaning, painting, repairs, without giving the proper proration or without understanding the lifespan.
Interesting. Fair housing allegations. This seems to be prevalent. What do you see going on with fair housing allegations?
It's funny because we just had a case with a fair housing allegation. There's multiple different aspects of fair housing where fair housing jumps in. And the condition of the property is one. We talked about the mold and different things that happen with the property, but we also talk about like Section 8, right? Or receiving housing vouchers. A housing provider has to be aware that you cannot turn a tenant away just because they receive housing vouchers. Like income, it doesn't matter where the income comes from. And so we're seeing a lot of litigation, or at least the tenants filing complaints regarding housing vouchers. A landlord told me that they don't accept Section 8, or they're asking questions that they shouldn't be asking in reference to, if they're married, family members, how many they have children, how many children, and you got to be careful the questions that you're asking, and then whether they're making decisions regarding the tenants moving into the property based on things that would be protected, not realizing it. And so, it's like I said, housing vouchers, Section 8, receiving, subsidies, that is a rising problem I see with.
And you both may want to comment on this, is poor documentations, or lease provisions that create a unnecessary exposure. Is what advice do you give landlords on the documentation side of things?
Everything should be in writing. I see that a lot too, whereas, oh, well, we have a verbal agreement. Well, what is the verbal agreement? We know that if they're paying rent, that's easy to be able to identify the amount of rent that you agreed to. But what about the other things in the lease agreement, if it's verbal, that you've agreed to? It makes it very difficult to be able to assess what was agreed, especially if it's not in writing. One, it could be you might not remember, right? Or maybe the landlord remembers, the tenant doesn't. And so you have to protect yourself. Everything needs to be written down to protect both landlord and tenant. And from a landlord's perspective, having a written lease agreement, such as making sure the tenant advise you as to any issues with the property, making sure the tenant's required to have renter's insurance, all of those things are negotiated and written in the lease agreement. But if you don't have that written, then you kind of put yourself in a pickle when it comes to some of those things. If you want to evict the tenant because they're not doing, like if a tenant doesn't have uh, renter's insurance, but it was never in the lease agreement, now the law doesn't necessarily require it. So you have to make sure you put everything in writing.
And use an
Yeah.
attorney. You know, you can download all kinds of lease agreements off the internet, but not all buildings and rental situations and tenant landlord relationships are the same. Those contracts work really well if you do modifications to them. Minor modifications sometimes, sometimes major. But a generic boilerplate lease agreement is not going to work for you. Get it customized.
I agree
Common.
because there's so
Yeah.
many different disclosures that you need to have with your lease agreement. And missing, you know what I find? If you We have the Tenant Protection Act now. So in 2019, the Tenant Protection Act has became a law that there are several exemptions that a landlord would have. And some of them are if you do not put the tenant on notice of their exemption, then you likely can lose that exemption. And you don't want to lose your exemptions because that allows you to be able to move in a way if you wanted to evict a tenant because of whatever reason, as long as it's not discriminatory reason, you would be able to do so. But there's a lot of restrictions on being able to evict tenant. You have the just cause law. You have they do allow for some no fault just cause, but if you have the exemption, then you're not you don't have to you're not you don't have to abide by that particular Tenant Protection Act. I mean, you still have to abide by California law, but you don't have those restrictions. And there are very many restrictions in the Tenant Protection Act. And I see that, and you have to put them on notice of that exemption in the lease agreement. And a lot of times I see that missing. They have a disclosure, so they'll attach the disclosure, but they'll forget to check that little box that says, I'm exempt. And then they lose the or potential of losing that exemption. So I see
And
a
Phil,
lot of things, oh, go ahead.
no, I was gonna say, Phil, when you see liability coming to a client, uh, are you are one of the first things you do is looking at the agreements and the contracts?
Absolutely. The contracts, the insurance, you need to make sure that they don't already have an issue. Yeah, everything that's existing is the starting point.
Yep. Got a question here on this subject. I'm going to answer now. Is this the same for a single family home? Because in Texas, we have cities that are known not to accept housing vouchers. Is a tenant rights protection a federal law or California?
Both, both. You have a single family home. I have a client now, single family home, and they said that they didn't accept Section 8. And so, and here we go, lawsuit, you know.
Yeah.
So yes, it applies to single family when in regards to vouchers.
Is
And
that
and there's
the act?
different laws state by
Yeah.
state, but all states have similar laws.
Okay. All right. And it's interesting because this week, Sakina, you know this, I think this was last Friday. Somebody came to the firm needing to evict somebody. And so this is one of the agenda items here is, the evictions, sort of the risks of DIY, property management, especially with evictions. What do you advise with evictions, because it can be very sticky.
I advise you to call an attorney. I do. There was a time where you could do evictions yourself because we didn't have the Tenant Protection Act. We didn't have all these additional laws. We have new security deposit laws. We have now you're required to have a refrigerator and stove. I mean, there's so many changing laws regarding housing. And I think the first thing you need to do is to call an attorney. Because there's attorneys out here who no longer want to do landlord tenant law because of the ever changing laws that happen.
Oh, yeah.
And now we have to deal with the Tenant Protection Act. We have a lot of local laws that come into play as well. But there are cities who've decided, you know what, nope, we want to tighten it up even further. And so they have their own laws that you have to think about before even making a decision on evicting someone. So the first step is to call an attorney. You want to make sure, one, are we subject, is this particular property subject to the Tenant Protection Act? Two, you want to look to see if the landlord had any exemptions from the Tenant Protection Act. Three, you want to see, are there any local laws that is the property subject to? Because you got LA, the city of LA has their own local laws. You have Santa Ana, they have local laws. You have the county of LA that has different laws from the Tenant Protection Act. So there's a lot of different things that come into play that I would say you need to make sure you understand before even drafting the notice. Even prior to drafting the notice, even if you want to do an increase, there's things that you need to look at before you increase the rent. So it's just always good to check in with an attorney first.
Sakeenah, will you tell somebody if they don't have a good case to evict somebody? I mean, I know the answer of sort of rhetorical question, but is that the first thing you look at, whether it's viable or not?
Yes, I want to make sure that you have a legal basis for evicting this person. And I want to make sure, like I said, okay, I want to know what law applies. I want to know, is there a local law that's going to apply to this particular property? If so, I need to make sure I like to reevaluate those local laws, and I do it on a consistent basis because changes happen so frequently. And so I'm reevaluating, I'm looking at that law to make sure, okay, did anything change? Because if something changed, because what was may not work anymore this day, in today's day. And so I look at those things and I want to see, okay, well, why are you evicting them? Is it non-payment? Is it a breach of the lease agreement? Is it sometimes for housing providers, they find out that the property is an illegal property. Maybe there weren't permits, or maybe there was something that happened to the property. They didn't know. They purchased a property and wasn't aware. I have a client right now where she thought that was a legal conversion of her garage, and it wasn't. And so now we have to deal with, she has a tenant in the property, and now we have to deal with that. But yeah, I would never start an eviction if I didn't think they had a legal basis to move forward. Because what's the point of getting all the way to the end and then you lose the case? In some lease agreements, you have to pay attorney fee, and so the landlord would have to pay attorney fees, and then there are also penalties if you file what they call, an eviction based on things that you shouldn't be moving forward with,
Yeah.
such as to illegally increase the rent, and then you're evicting them because they didn't pay the illegal increase.
When someone walks into your office, uh, you know, are there things you tell them when it comes to like inconsistencies of managing the property? Because I see that a lot, is that there just isn't consistent processes in place for how they manage tenants, which can lead to liability. So do you talk to people about formality, being consistent, best practices, treat it like a business?
I do, because okay, so before I became a lawyer, I was a business owner. And so I have a business background. And so I understand the business aspect, the operational aspect of it, as well as the legal aspect of it. And so when they come in, my clients come in, or prospective person come in, I'm looking from both sets of eyes. I'm looking at, okay, having certain process and procedures can save you in the long run, from having to, on the legal aspect of it, right? So we want to make sure that you're doing things in a certain way. You're inspecting the property at least every year. We want to make sure you have everything in writing. And you want to make sure if you want to make any changes, such as, like I said, a rental increase, or you want to, renegotiate the contract, you want to make sure you actually can. If you want to go convert from month to month to now a year contract, we want to talk about those things. What does this look like? Is your tenant in agreement? We want to, talk about, are you exempt from the TPA? We want to look at the whole picture. But yes, operational, that's important, because a lot of times landlords will come to me, they have several properties and they're all under their own personal name. So they haven't even put the properties in an LLC to give themselves some protection. And I know Phil can talk more about that, the importance to separate yourself from your property. Um, yeah, so the operational part of it is just as important as the legal part.
Yeah, Sakina, great transition because Phil, I want to get into building the fortress here because what we deal with at the firm, of course, on the asset protection side and the estate planning side, but it is guarding the property. So if there is liability, you've got some protections in place. So let's get into this. So understanding liability exposure. Could you talk a bit about insurance, what role that plays in protecting your property and how it marries with asset protection?
Yeah, and I apologize. My wife got stuck in a traffic accident on the freeway, and so I have my 9-month-old. So if there's any noise, I'm sorry. But
Hope
yeah,
she's
so
okay.
one of the most common things that I hear from landlords is even when they've done things right, they didn't do their asset protection, and they say to me, they say, I wish I had done this sooner, because if you come to me when there's a situation, we can maybe build some speed bumps, make it a little bit harder for creditors, but we can't really stop them from getting to your assets. But if you come to us in advance, we can build a fortress around your assets. That's the big difference there. And so, fortresses have layers. And so the first layer of defense in the fortress is insurance. Do you have insurance? If you have insurance, do you have the proper type of insurance? Have you reviewed your insurance policy? When you look at any insurance policy, it doesn't matter if it's umbrella or property insurance or auto insurance. The first few pages are what's covered, and the next dozens of pages are what's excluded.
Yeah.
Insurance companies don't stay in business by paying out on your claims. They're going to try not to. And so it's really, really important to work with an insurance professional or an asset protection attorney or both to make sure that your policy covers the things that you need it to. Does it cover the Amazon delivery driver that comes on your personal property or maybe your rental property or whatever the case may be? Lots of things like that that people don't think about, and insurance will specifically exclude.
Well, that's an interesting comment because about 8 months ago, we had a case and came to our firm, a woman who, this was in the Bay Area, had a legal unit where she lived. She lived in the Bay Area, legal unit, and there was a therapist that lived there, like a massage therapist, and somebody got hurt. Like a client came to this legal unit, got hurt. There's a liability, and the owner of the property said, "Well, I've got insurance for this." And Phil, this insurance company said, "Well, you don't have the right type of insurance because this was a business thing, which shouldn't have been going on the property." So she was fully exposed. And uh, anyways, it's just right in line with what you're talking about.
And
And
you know,
even
I get that a
titling,
lot with, oh, sorry.
I would say even titling, a lot of insurance companies are trying to say, well, you have a trust in place and the trust isn't covered, so we're not going to cover your property. It's really important to make sure everything is covered, every basis. If you have an LLC, make sure the LLC is named insured as well.
Sakina, you were going to say?
I was gonna say I get that a lot with clients and prospective clients coming into my office where something happens on the property and they don't have insurance to cover it. Because the insurance will kick in if they have the right coverage, the insurance will kick in and help litigate the matter for them. But without that, you're on your own, you have to pay for it. And litigation is expensive.
Well, and I hear often, Phil, you say, staying on insurance here for a second, is that there's zero correlation between the amount of insurance you have and the amount of the liability. Right? It's not like they match up. So people that say,
Absolutely.
"Oh, I've got 1.5 million of insurance liability," well, big deal. What if? And this is one of the issues here, and I want your opinion on this: is what happens if the damages exceed the insurance policy? What does happen there, and what do you say about that?
Yeah, absolutely. There's a lot of times that you get attorneys out there just looking for the insurance payout, but that's not always the case. Some people, especially when there's a serious injury or even a death involved, they're looking for a lot more. They're looking for, retribution and to punish the person that did them wrong. And so 1.5 million isn't going to cover much of anything. And once your insurance caps out and won't pay anymore, then your assets are liable for the rest.
It kind of sounds like a Goldilocks scenario. Not too hot, not too cold with insurance, right? You don't want too much where it's a pot of gold for somebody to go after, but not too little where it doesn't cover things. Is that a fair statement?
Definitely. That's one of the reasons you need to have a professional review it.
Well, all right. Well, this gets into, and by the way, I want to encourage anyone here, questions, if you want to put some questions in the Q&A, happy to address those along the way. The more interactive for us, the better. We love it. We just want to be a resource here. Let's talk about LLCs, Phil, and when LLCs make sense, and then the common mistakes owners make with LLCs.
Yeah, LLCs are a great secondary layer of protection. You know, they almost always make sense, but not necessarily just by themselves. Sometimes that LLC needs to be coupled with an irrevocable trust or some kind of other strategy because the LLC in and of itself won't protect you. The biggest mistake that I see by far is somebody putting all of their assets into one LLC. Now, let's say I've got $5 million in assets in my name. So I don't have any asset protection whatsoever. So I decide, okay, I read on, Chat GPT or Gemini that I should put my assets in an LLC to protect them. So I go out, I set up a California LLC, file my statement of information and articles with the state, and then I transfer all $5 million of my assets in the LLC. And I think, great, I'm protected. Well, I get let's say one of those assets in there is a piece of rental property, then and somebody slips and hurts themselves there, and I get sued by the tenant of that rental property. Now, every asset in that LLC is subject to the rental property, so that LLC has provided me no protection. All my assets are still 100% exposed. And that's the biggest thing that I see. You've got to separate the liability from the assets. And trying to find where that fine line can be difficult. You may have like an office building, and you may have your office and business running through that building. So you need to make sure to separate those two. You have to get a separate entity for your the building itself and a separate entity for your office, the operating business, and then lease the building to the office. You've got to make sure you separate that liability. You don't want to put stocks in with real estate, assets that have no liability in with assets that have liability. There's a lot of little nuances. And then setting up the LLC. People, read again on AI, oh, Nevada is a fantastic state to do asset protection, and I'm going to set up a Nevada LLC for my California property. And that's all they do. That's not going to get you protection. You have to take the steps to make sure that it's protected in California as well as Nevada.
Yeah, no, this is a question here. And yes, Camille's asking, is Phil an asset protection attorney? The answer is yes, has been for many years, one of our top attorneys at the firm in asset protection. And she's asking, do you need an LLC for every property? And this came in this last week too, is someone came in, they have 48 properties in one LLC. And so my Phil, I'm going to ask you this because they have 48 properties. Um, do you get 48 different LLCs? I mean, because can't that become expensive and administrative nightmares? What do you do with someone who's got 48 properties in one LLC?
Yeah, so definitely 48 in one LLC does no good. So one of the
Why?
options is because you combined all your assets together, and if anything happens on one of the 48, all of the other 47 are exposed to that liability and to the loss.
Oh,
So sometimes 48 LLCs is an option. It's extremely expensive, but it depends on the state. There's some states where it's only cost you like $50 a year for an LLC. Another option is there's 13 states that offer something called a series LLC, where you have one parent LLC that has a bunch of sub LLCs under it, and you put each property into a sub LLC. That could be an option as well. You could do 48 irrevocable trusts instead. It really just depends. There's no one answer for everybody, and it's really dependent on each client situation as to what the correct answer is. To Camille's question, I think she asked if you should put if every LLC, every property can have an LLC. Not necessarily. There's sometimes where you don't want to put a property in an LLC. One of the biggest examples is in Hawaii and Florida. They have a transfer tax. If you put your property in an LLC, you've now got to pay a hefty transfer tax on doing that. So there's better ways to protect a property in those states than
oh,
putting it in an
interesting.
LLC. And
Yeah.
so it's just, you've got to you got to consult with a professional to look at every asset you have and all the nuances to determine what's going to be the best strategy for you.
So when you're and when you're sitting down with somebody, I mean, I know we have our legal insolvency analysis we do, but when the scenario is big enough, you're turning over every rock and looking at what the personal circumstances are and laying out a blueprint.
Absolutely. And sorry, I was also reading. Rick had a question as well. Say that again, Paul.
Well, yeah, I'm just saying that, every scenario is different. You're
Hmm.
turning over every rock there and tailoring the approach. But yeah, these questions here, if the homeowner has passed away, has a trust, how can the successor trustee add the trust to the homeowner's insurance?
Yeah, you just call your insurance company and you let them know that the trust needs to be an additional named insured. Yeah,
Okay.
the fires in LA triggered this. A lot of insurance companies are trying to deny coverage because of this. It's probably not going to hold up in court, but how many of you want to spend $50,000 on a lawsuit to fight this? Just get your trust as an additional named insurer on it. And then to Rick's question on the series LLCs, have they been tested in court? It's kind of the Wild West still. There's some states that do really protect their series LLCs and other states that don't. Again, it's an individual analysis. Is that the best option or is there a better option for you? It really just depends.
hmm Uh, and what about the admin part of it, mixing personal and business assets? I mean, I think that's a big no-no, and you just got to be diligent about keeping things separate, Phil.
Yeah, you definitely want to make sure that you have a bookkeeper or somebody that really knows how to deal with these things because one of the ways to pierce through an LLC is if you haven't treated it like a separate valid entity. And if you're paying for personal expenses out of there, if you're paying for business expenses out of your personal account, using the wrong credit card for something, a lot of times that's a way to pierce through an LLC. And so you really need to make sure that you're paying for business expenses with business funds and personal expenses with personal funds, and you're not constantly doing owner contributions and distributions to pay for things.
Yeah, and I'm going to get to Ray's question in a minute, but on this topic here, you know, there's 40 million lawsuits filed in the U.S. every year, and many of those are directed at landlords. And we get about 8 hair on fire calls a week into our firm, people dealing with liability and lawsuits. And what happens is if it's substantial enough, and there's these contingency fee attorneys on the other side, and Phil, you can acknowledge this, and Sakeenah, I'm sure you run into them also. They're going for it. They attack, and they are going to look for any little thing they can find to get their foot in the door. You see that? You see that often?
Yeah, and contingency is very unique to the United States. Most countries don't have that, and it causes all the lawsuits. It's allowed an attorney to partner with you in trying to sue somebody for money, where somebody wouldn't have the money to fund the lawsuit, now they do. And so you get a lot of not necessarily BS lawsuits, but a lot of lawsuits that lack a lot of basis and should have never been filed in the first place because of it.
Yeah. Yeah. And Ray's asking, how do you transfer property into an LLC if it hasn't been fully paid for yet?
So that's kind of an interesting scenario. So technically, most mortgages are going to have a due on sale clause in there. And that due on sale clause says if the title changes in any way, shape, or form, that the lender is going to call the loan due. There's two things there. One is I myself have done thousands of transfers of finance property into LLCs, and I have yet to ever see a lender call it due. I know the firm has done tens of thousands, and I have never heard anybody in the firm say that they've had that issue come up. If you really want to be safe, you contact the lender and say, hey, I'm trying to protect your asset that you've got a lien on. Let me put this into an LLC for asset protection. I'll show you that I'm still the owner. That there's nothing changed there. I'm the owner of the LLC. The LLC owns the property. I'm still on the hook. You've still got a personal guarantee from me. You've still got you've you've still got a security interest in the property. Just let me put the LLC on there.
And that's
Phil,
what I
you're
do
multi,
Phil, with my clients.
yeah.
We have a letter we send out to the lender just putting them on notice. They usually ask for a copy of the operating agreement, or something to show that the transfer, the same people are the same people. And then we've never run into any problems with that.
Well, you can run into problems, can you not, if the ownership is changing? For instance, it was 50-50 before the LLC. Now you're going 100% this one person. That's an issue, right?
Absolutely. The lender could have an issue, but the bigger issue is in California, you now have a Prop 13 issue, and you could get a property tax reassessment if it's not done properly.
Okay. Well, nobody wants that. And I gotta say, Phil, your multitasking capabilities are incredible with that kid. I love it. Uh, no, very interesting. All right, we've talked about isolating liability here, protecting your personal assets. I don't want to bring up, because this is something that a lot of people don't think about when you own rental property, is the difference between inside and outside liability and how having asset protection in place guards from both. Can you comment on that?
Yeah, so inside liability is what I was talking about before. If you have, 48 properties inside one LLC and something happens to one of those LLCs inside, all of them are exposed. Outside liability would be, say, you get in a car accident and somebody sees you, then they try to get to those assets inside. That's outside liability. Um, LLCs are very, very good asset protection for inside liability if you keep all the assets separate. But there's a little bit of hiccup with outside. You get something called charging order protection, which means that nobody can take the LLC from you, nobody can take the assets from you, nobody can force you to pay them. But because of the charging order, you're stuck with keeping any money inside the LLC. Anytime you distribute profit to yourself from the LLC, that's no longer subject to the charging order, and that can be garnished by the creditor. So, one of the ways to get around it is you put that LLC into an irrevocable trust that's for your benefit, and then the distribution goes to the trust rather than you, and the creditor can't get to it. So there's, many different ways to plan in case of an issue and a threat.
Yeah, an example of that that came in to our firm is this was in Napa Valley, California, and it was husband and wife driving, car accident. It was his fault. There was an injury, and he was sued for a couple $1 million, and they went after his rental properties in San Francisco, his brokerage accounts, and they owned a business, which was not an LLC, it was an S corporation. But my point there is that liability touched on that rental property, and it was a car accident, it had nothing to do with the property. In that circumstance, Phil, the proper LLC structure is going to put up a barrier there.
Absolutely. And I'm going to take that one step further. I'm dealing with the one we just got a call a couple weeks ago where the client's son started driving and was drunk and killed somebody. And now
Oh
they're
my
suing the
God.
parents for their assets.
Horrible, horrible for everybody involved. Jurisdiction matters. This is a big deal. And again, when we talk about this, I know, Phil, I've heard you say many times, is that having asset protection in place is like having it like earthquake insurance on your house. You got to have it before the house starts rumbling, right? You're not calling the insurer saying, "Hey, my house is shaking. Can I get earthquake insurance?" So, and this is if something happens, knock on wood, hopefully nothing ever happens that's devastating for you. But if it does, this is why you have it. And why does jurisdiction matter?
Yeah, jurisdiction's a big deal. Not all states are created equal when it comes to protection and insurance and things like that. Different states have different rules, and where your property is versus where you are matters to what rules get followed. And then once you set up an LLC or an irrevocable trust in another state, now that state's laws come into play. And so it's really complex to navigate how one state's asset protection laws or lack of asset protection laws in California's case work with another state's asset protection laws and which one's going to prevail over the other one. And so it's really, really analysis that needs to be done on a state by state basis and an asset by asset basis.
Yep. Okay, I'm going to blaze along here because I want to get into this. This is a pivot, and we often say, and I hear you say, Phil, I know Sakeenah, you know this too, is asset protection is a different discipline from estate planning, but integrated in many ways. I've heard you say that, Phil. So, talking about property, this comes up a lot with us is families that are getting the property to the next generation and all that's involved there, inheriting, a property. So, a parent passes away, leaving, rental properties to three children. And you've got issues of one property contains a non-paying tenant, another has a family member living there. There's some maintenance that needs to be done. But what do you start talking about, Phil? And Sakeenah, you can chime in here too on getting property to the next generation when issues are going on. And I know in California there's Prop 19, but what do you get into?
Yeah, so, estate planning is a big part of this. If you die and unexpectedly and these problems get passed on to your kids, the first and foremost problem is who has authority. If you don't have a trust and you don't have the assets titled in the trust properly, then those assets will have to go through probate. And probate is not quick. It can take anywhere from 6 months to 2 years. It can cost tens of thousands of dollars to the estate, and nothing can be done. If you have a client that's not paying rent, that's destroying the property, maybe doing something that could force you to lose the property, they're selling drugs out of the property. There's a lot of states and counties starting to look at taking real estate from homeowners that have drugs moving out of their house. And so you could have this situation and there's nothing you could do. You couldn't get the police to help you. You couldn't get the courts to help you until you have authority, which like I said, could take months through the probate court. And so you really need to make sure they're titled properly in a trust, and not just titled properly, but the trust is specific on who has the authority to control those. And then once that's done, then you can start to take some action. But now you have, let's say you're the beneficiary, you now have inherited a headache. And you want to make sure that you haven't inherited something that's going to expose your assets. So let's say there's a pending lawsuit on one of the properties you inherited, and you've got significant assets of your own. You don't want to lose those assets. So you want to make sure that those properties are held in a shield in a bubble so that they are completely separated from your assets and that the liability goes away from you.
Sakeenah, I'm going to ask you this, and I see Wayne has a question, but removing inherited tenants. This comes up a lot in our firm. We get calls where parents have died, kids are not on the same page, there's not a lot of communication going on, and like we get a call from someone who's in the dark saying, "What is going on? My siblings living in the place, rent free." Do you get involved in this, trying to deal with the removing inherited tenants or issues around that?
Yes, yes, I do. And it goes back to what you were saying about the operational aspect of being a landlord is having everything in writing and having, making sure one, if a written lease agreement, right? So that we know what the terms are. A lot of times I have a client now who's trying to do all of that. He wants to get everything in order because he knows that when he passed, he wants to make sure his children doesn't have to worry about, did they have everything in order? Was there a lease agreement? Can they evict them? If there's an exemption, did he make sure he exercised his right for that exemption? Because you might not be able to get someone out. You would have to have a just cause reason. Another thing I notice a lot of times is that there are a lot of housing providers who never increase rent. And so with the market changing, you have people paying, let's say $1,600 a month, but the property's worth $4,500.
Yeah.
Now, if you didn't do the proper exemption, how do you increase the rent to what the market value is? You can't. And so, yes, making sure everything is in order for your heirs, whoever's going to be taking over your property when you're no longer here is important.
Just got a question here. Middle, I'm in the middle of a lead-based remediation issues on a sixplex. No threat of litigation, but expect it to happen soon. Is it too late to buy insurance for lead-based paint specific policy and any recommendations? But maybe both of you have some comment on that one.
I don't really know anything if it's too late to buy insurance, but we work with some fantastic insurance professionals that are part of our asset protection team. And I could definitely put you in touch with one of them that can evaluate and let you know an actual answer to that.
Yeah. Yeah.
It makes it a little bit difficult when you're in the middle of something to then want to get insurance to make sure it covers it. But, he should check with his insurance company, his current insurance company, to see if there's coverage.
Yeah. Phil, are you thinking of Jerry or someone else or
Yeah,
someone like
definitely.
that?
Yeah.
Yeah. Yeah. Yeah. For anybody who has a question about that, we do have a member of our extended team who is the principal of his insurance firm. He actually has done quite a bit of education with us for our apartment association. So reach out. We'll get connected to Phil, have a conversation. Um,
And you can see Jerry talk on our YouTube channel, Wealth Protector TV. He may have talked about this topic before.
Yep. Yep. Another question here. I want to take these questions because we love the engagement. If there was a form notifying them of that lead-based paint is still there, is that still a grounds for a lawsuit?
Yes. Yes. And I say it just depends, right? But there is still grounds for a lawsuit, but it definitely depends. You know, you put them on notice, that's important to give the disclosure. If your property is over a certain age, you want to disclose to tenant that there's potential lead base available because you may not even know that it's lead based paint, but you do have to put them on notice because your property is over a certain age.
Okay.
But
And
will the
yeah.
tenant still use that, as an excuse to file a lawsuit? Absolutely, they do it all the time,
Hmm.
right? It's not always whether, sometimes it's when a lawsuit happens, um, the question is not always about liability, it's about the cost associated, right, with this lawsuit. And the lawsuit is expensive and they know it. But they're hoping, a lot of times the tenants are hoping, one, you have insurance, so they can just go through the insurance company and the insurance will usually settle or pay out if there's some inkling of liability. But then they're also hoping that you will settle because you know the cost associated with moving forward with a lawsuit,
Yeah.
right? It's going to cost you 50, $100,000, but they're asking for 10. What do you do? Do you pay the 100 or do you pay the 10?
Yeah. Yeah. You get into those negotiations with clients. You advise them on how to resolve those things.
I do. I do. My goal is to make sure I advocate for my client, but I do want them to be aware of the costs associated. And sometimes you're like, well, I want to keep going just based on principle. And I just remind them this is business, right? It's a business
Yeah.
decision, so
Yeah.
we should look at it as such.
Yeah. Um, Uh, I put the YouTube link in there in the chat. People can see that. That's our Wealth Protector TV YouTube channel. We got a ton of education up there. As a matter of fact, this replay will eventually go up there in the next few days. So click on that. I have a difficult tenant living in my building for the past 7 years with no lease. How do I get the tenant to sign a lease now?
Well, they're month to month, so you can ask them to sign a lease, but you can't force them to sign anything more than a month to month lease with the new Tenant Protection Act, right? And so maybe what you can do at this point is, I know they're difficult, but because you want something from them, you can approach it from a friendly perspective, right? You want to make sure everything's in writing. You want to make sure, this is for their protection, which it is. And
Yes.
maybe you can get them to agree to sign a lease agreement. The problem is you can't force them, but you can
Sakina,
see
can
if you can
you
get
can
them.
you just terminate their tenancy?
You can terminate their tenancy if you have a just cause reason to terminate their tenancy. Now, if you're exempt and you put them on notice of your exemption, you can just terminate the tenancy. You don't have to have a just cause reason. So that's why that exemption is important. And with most, I don't know if this is a single family or if this is a multi-unit. So I would need more information to be able to determine what
Yeah, I was gonna
route to
say it
take.
sounds like this is a case by case basis and property by property basis, and really the answer is contacting an attorney.
Pretty much.
Yeah, and Wayne's following. I just put Jerry was asking for the contact information, Jerry Connery, and then can't terminate in multifamily in Oakland. I guess there's a local law
Oh
there.
yeah, but the multifamily, you're stuck to that Tenant Protection Act. You're definitely hands are
And
It,
tied.
Sakina, you'd be happy to do a free consultation for any of these, right?
Oh, for sure. Definitely.
Yeah, and again, that link, I put that link for the free call. If you fill that out, that is to get you connected to Sakeenah and or Phil. Do landlords carry liability? Oh, let me ask this first question. Well, I'll stick with Jane for now. I'll go back. Do landlords carry liability after tenants move out as it relates to lead disclosure that was provided at the beginning of tenancy?
What type of liability? I'm not sure I understand the question. If they've already moved out.
Yeah, Jane, maybe you could expand on that. Do
I wonder if
landlords?
she means like if an injury is found after they've moved out, maybe something along those lines.
But they would have to definitely be
Correct,
able to
correct.
tie
Yeah.
it to that particular property, right? Because after they move out, who's to say where the industry where they were injured, right? It's hard to be able to determine that they were injured at the previous property in which they lived.
But
So it makes it,
I think they still can be sued for it, right? It's up
oh
to the
yeah,
person
if they can
suing to
tie it for
prove
sure.
that it came from your property.
Yes, that is correct.
In many cases, when a tenant is going month to month, can the rent be raised to help them make a decision?
If it's month to month, you can raise the rent, but there's a limit on how much you can raise the rent. And you can only do it, you know, pursuant to that limit once a year. So, it's you're subject to TPA. It's 5% plus CPI, not to exceed 10%. But if it's a local city could have different rules, and in which the amount is much lower.
Okay. And Sam's asking, he missed the introduction. I'll just reiterate, Sam. Phil Shekerlian is an asset protection attorney at Barth Calderon here in Orange County. Sakeenah Redmond is a landlord attorney, founder of her own firm. Both big speakers across the country on these topics. So Camille's saying, but if they didn't state there was a health issue while at the property, isn't it hard to prove?
Well, they would have to prove their case, right? So they would have to prove that they were affected by the lead-based paint while living in that property, and they
And
would be
also
able
that
to
they
have
weren't exposed to lead-based paint anywhere else.
exactly, exactly. So they would have to prove that, and so it could be very difficult to prove.
Okay. All right, as we're bumping up again, oh, here, let's get Ray. I have a tenant who always pays late. Can I terminate the tenancy when the lease is up for renewal? Are there any liabilities?
Again, it goes back to that TPA. You can't if you don't have an exemption, you can't just terminate at the end of the lease if they've been there for over a year because if it's your property subject to Tenant Protection Act. Now, what you can do is the moment they're late paying their rent, give them a 3-day notice to pay or quit. And if they do not pay within that 3-day notice period, do not accept rent, move forward with an unlawful detainer.
But you also got to be mindful of what your lease agreement says. What is late? And maybe it says that there's a penalty for being late or not. And again, it's everything's a case by case basis.
Yeah. In most lease agreements, like you said, you do have to be mindful of your lease agreement. Most lease agreements will allow there to be um like a 5-day grace period, in the car forms allows a 5-day grace period. However, it does not alleviate you from being able to move forward with a 3-day notice to pay or quit after, like if the rent is due on the first and they don't pay it by the first, even though it allows for a 5-day grace period, you still can move forward with an unlawful detain a notice, I should say, not an unlawful detainer, a notice to pay or quit.
It was great information.
Most of the lease agreements, what it's saying is that I won't charge you a late fee, until after the 5 days. Not that your rent is not due until the fifth. It's usually that I won't charge a late fee. Is what those provisions usually state. But you have to check your lease agreement. Everything starts there.
Okay, I'm going to say a couple of key takeaways here. Many landlord lawsuits are preventable, is what I've heard. Documentation wins cases. DIY legal work often becomes expensive. Insurance is one layer, not the complete solution. Ownership structure matters. State planning protects more than wealth. It preserves decision-making authority. Good planning allows families to act quickly during difficult situations. The best legal strategy is almost always proactive rather than reactive. Would you add anything to that list, either of you? Or you think it catches it
I think
well?
you pretty summed it up. You pretty much summed it up.
And with estate planning and asset protection for that matter, the further out you do it, the more options are available to you. The closer to an issue you get, the less options you have.
Yep. I want to answer this question. Can I, with a duplex in Orange County, not renew a lease at the end of a 1 year term? It was and is a month to month with the rent rate for 12 months.
I say it depends, and it depends on whether you live on the in the other unit as a landlord, and if you don't, a duplex would be subject to the Tenant Protection Act, and so unfortunately, you would need a just cause reason you don't live there.
Okay. Okay.
But there's
Awesome.
there's other exemptions in the Tenant Protection Act that you could possibly qualify for. So you want to look it up. And again, I will offer a free consultation if anybody wants to discuss further on how to evict their tenant or some other
Okay.
issues with landlord tenants. Mhm.
Love it. Okay. Again, that link, and yeah, says thanks to live there part-time and rent it part-time,
Yeah.
there.
Yeah. Have her give me a call because there's some other things I want to be able to look at to see if there's any exemptions that could possibly apply.
Sakeenah, I'm going to put your email in the chat. What's the best email?
S is in Sam, Redmond, Redmond, at S is in Sam, N is in Nancy, R is in Roger, lawgroup.com.
Okay. Sakeenah's email is there. Feel free to email her directly. I will be sending out the replay, and someone's asking about the list I just mentioned. I have that list. Actually, it's a more robust checklist I'll be sending out. As a landlord, go through there, and you can score yourself. And if you're getting high scores, you're in trouble. But take a look at that. I'll have you a checklist for you. Phil, Sakeenah. Awesome. I really appreciate being here, and everyone keep focused on us because we're doing tons of education, and we're going to have both these experts back. Thank you both.
Thank you everyone for your time
Thank
and
you.
listening today.